Hello everyone. So this is going to be fourth video in series of our discussion on Supreme Court. In the first three video where we spent around 5.5 hours in those three videos. In the first video, if you remember, in the first video we had discussed the method of appointment, National Judicial Appointment Commission, how it was struck down by Supreme Court, how collegium system evolved, how collegium system worked. In the second video we discussed about the impeachment. In the third video we had detailed discussion about jurisdiction and powers of the Supreme Court. So this is the fourth video, and in this fourth video there are some leftover topics that could not be discussed with the flow of the lecture, and this fourth video is dedicated to those topics. So if you see what are the mechanism that has been mentioned in the constitution that ensures independence of judiciary, so this has been the first topic of this video. Thereafter, along with the constitutional mechanism, there are judicially evolved mechanism as well. So the collegium system, which again ensures what you call independence of the judiciary. So this is not a constitutional mechanism, mind you, this is a judicial evolved process, right? So we'll see what are the constitutional mechanism which ensures judicial independence from the executive, from the legislature, and what are the judicial evolved process that again ensures the independence of the judiciary. So that will be the first vertical. In the second vertical, right, seat of the Supreme Court. So you have this article 130 which talks about seat of the Supreme Court, which will remain in Delhi, although we'll discuss that Chief Justice of India does have power that he can change the seat of Delhi or can have additional seats of Supreme Court in other parts of India with the previous consent of the president. So that will be second vertical, although these topics are not going to be very lengthy. So within 35 or 40 minutes probably we would be able to cover all these topics. Then you have this class of advocates in Supreme Court. You have this advocate on record, what is the senior advocate and what are these other advocates. So these class of advocates we will discuss, and in the fourth and final leg, right, we will discuss languages in the Supreme Court. So can you use Hindi, can you use Telugu, can you use any other language that has been mentioned in the 8th schedule of Indian Constitution that deals with official languages of India. One vertical that I have not put up here, right, we'll discuss in the same video the mains question as well, that in which area, not mains question as such, but what are the areas from this chapter called Supreme Court from where if question has to be framed by examiner, so from what areas, all area mains answer can be framed. And in the last there are 4 or 5 MCQ that we have put up that you need to post in the comment section. So this has been the job of, or this is the scope of this video. So let us start to discuss the first topic that deals with mechanisms to ensure the judicial independence. So the first, if you see, we started our video, the first video was dealing with the mode of appointment. So mode of appointment, if you would have seen, right, you have this collegium system. If I talk about how constitution has envisioned appointment of Supreme Court judges, so you had this article 124, and article 124 talked about that president will appoint Supreme Court judges in consultation with the Chief Justice of India. But if you remember, there was a wide debate between that particular word consultation. I am not getting into the detail because you must have seen the first video. If you have not seen, we had spent around this word consultation. What was the meaning of consultation? So does that mean concurrence or not, right? Because in article 124 it talks about that CJA president in appointment of Supreme Court judges, right, should always consult Chief Justice of India, right? He should always be consulted. But what was the meaning of consultation was not clarified in this article, and that led to abuse of this word in 1970 to 1977, how there were appointment and transfer of Sarkari judges, right? So all those discussion we had in length, how there were two judges, this HR Khanna and the other judge who was superseded, they were not made Chief Justice of India. So we had discussed in length. Finally you had the 3 judges cases, first judge case, second judge case and third judge case. first judge case in 1981, then 1993, and third judge case in 1998. So how this collegium system came into existence through this second judge case, and how this was further consolidated, the collegium position was further consolidated, and it was reiterated in this presidential reference in third judge's cases in 1998, right, through which the position of collegium system was strengthened, right. And now after the establishment of collegium system, the method of appointment came to be where judges will continue to be appointing judges, right. And it was clarified through these this second judge's case, right, that this word, meaning of this word consultation, where we had wide debate, again I am saying that meaning of the consultation will mean concurrence, right, concurrence of whom? Concurrence of this collegium system that was created in this second judges. I hope you would have understood. So mode of appointment is, again, if you see right now, judges are appointing, this collegium system is appointing judges in Supreme Court and High Court, right. So this is nothing, this mode of appointment through collegium system is nothing, it is another name of independence, or you can say that this method of appointment is nothing, a mechanism to ensure the judicial independence, right. You have no role of executive. The role of executive had the executive and legislature both had tried to carve out its role in 2014 through this 99th amendment, by which this body called INJAC had been created, but this was, again, as I said, that in 2015 without a single meeting this body was declared invalid. 99th amendment was struck down, saying it violation of constitutional principle, describing it as violation of something called concept of separation of power. It was described as that this 99th amendment is nothing, it is an attempt by the legislature to invade into judicial era and to attack on this judicial independence. So with these kind of strong comment, judiciary, and there were other nuances as well that we discussed in that video. So it's not that completely they were completely attacking on this legislature, but again they had some reasonable argument through which they finally struck down this 99th amendment. And right now the position is that judges are appointing the judges through the collegium system. So again I am repeating myself that the collegium system is nothing, a mechanism to ensure the judicial independence. Now if I talk about salary and allowances and other expenses. So salary and allowances we already have, again I am saying we already have discussed, the salary and allowances are charged. By now you would have become familiar with this word called charge. So if there is something that is charged on the consolidated fund of India or consolidated fund of state, we'll discuss when we'll talk about High Court judges. So their salary is charged on the consolidated fund of state, while the salary, pension and other allowances of other expenses of Supreme Court. So whatever administrative expenditure, it's not only salary and allowances of judges in particular, rather other expenses that Supreme Court does. So you have these administrative staff as well, you have whole of the organizational structure on which expenditure occurs. So all these expenditure are nothing, those are charged on the consolidated fund of India, because had it been at the will, at the mercy of legislature, right, then legislatures would have twisted or tried to twist their judgment in a certain way, or called itself that आप अपना जो expenditure और reduce कीजिए, otherwise means indirectly there would have been attempt to invade into their independence, right. So by ensuring, and this is a constitutional provision, let me tell you that these all expenditure related to the Supreme Court will be charged on the consolidated fund of India, right. So constitution has again through this mechanism as well envisioned nothing else but judicial independence, right. Then freedom to appoint its staff. So it's not only Supreme Court judges, right, through collegium system that Supreme Court judge can appoint, right, their administrative, their clerical staff as well. As I already told you that Supreme Court is not the front line judges that we see, right, the 33, 34 judges, whatever they do have, 33 plus 1, right. So whenever we refer to the Supreme Court, generally our mind goes that it is all about these judges, but there are thousands of staff that keeps work in the background, their administrative staff and their clerical staff, right. So they do have freedom, the judges does have freedom, they do have this organizational structure, and the judges has been given independence, right? So to avoid any kind of spying, to avoid any kind of snooping by the legislature or executive or by anybody else, right, this freedom again has been given, that you alone can appoint your staff. Then they have been given this security of tenure. So while discussing the qualification, we had discussed that there was some qualification, that as soon a person has attained some level of qualification, like 5 years in any of the high court, or either single high court, or 5 years in succession in multiple high court, or if any person has been practicing as advocate for around 10 years, then he becomes eligible along with being citizen of India, right, if he fulfills. Or the third requirement was that if he is a distinguished jurist, right, then as well, right. So if any person is fulfilling one, the first requirement is this, and any of the requirement of this B category, right, then he can be appointed Supreme Court judge. So security of tenure means once you have been appointed, there is no way except process of impeachment, and this process of impeachment for this removal, although again I am saying that in constitution this word impeachment in relation to the Supreme Court judges has been not been used, but you had this Judges Inquiry Act, if you remember, Judges Inquiry Act 1968, where this word impeachment has been used. So once you have been appointed, once a particular person has been appointed judge in Supreme Court, thereafter, except this process of removal, there is, and mind you, this process is going to be very difficult, and it is owing to this difficulty in removal of these judges that in judicial history of 69 years of independent India, that no judge has ever been removed, right. So that has been the reason, and that's why it has been called that they do have security of tenure, that unless you bring in parliament, right, the motion for their removal, so whichever house is trying to remove any of the Supreme Court judge, right, they'll have to institute first an inquiry. After that inquiry, both the houses need to pass it by 2/3 of the special majority. So it is owing to the difficulty that is involved in the removal of judges, right, it has been called that they do have the security of tenure. They are not at the mercy of pleasure of president. So the pleasure of president doctrine, right, pleasure of precedent, right, that we'll see when we'll discuss other constitutional body or other statutory body. So that is missing here, right. They are not lying in the Supreme Court with the mercy of president or with the mercy of executive. There is well defined, very difficult procedure in the constitution itself that again ensures judicial independence. Then conduct of judges. So their conduct cannot be discussed outside the parliament, and even in the parliament their conduct, their behavior, their judgments can be criticized only when their removal process is being discussed, right. So suppose removal procedure, right, only then you can discuss their conduct, their behavior, and it is not judiciary's behavior. In reality, it is that particular judge's behavior that you can discuss even when this removal procedure is ongoing. So that is again nothing but a mechanism to ensure this judicial independence. So does not matter what kind of judgment they give. So suppose in Ram Temple or in 370 or in CAA, if judiciary has delivered some judgment and any particular political party, owing to the vote bank that they may have, right, if they are not appreciative of their judgment in relation to CAA or Ram Temple or 370, right, and if they want to criticize, they cannot criticize in the parliament, and even outside the parliament, if they are criticizing, they'll be criticizing this judiciary at their own peril, because we'll discuss this power to punish for its contempt. So you have this article 129 that deals with court of record. So court of record, if the powers and functions or jurisdiction of Supreme Court, you would have seen in the third lecture, right. So in third lecture we had discussed this article 129, power of contempt of court, right, in very detail. So Supreme Court does have power to punish people for its own insult, and this is nothing again to ensure that judicial independence remains, right. Then ban on the practice after retirement. So Supreme Court judges cannot, after their retirement from the Supreme Court, they are not allowed to practice as advocate in any part of India, in any court of India, right? So that again ensure कि last के 2 या 4 years में, right, they do not give a biased kind of judgment in the hope that post retirement they will be awarded by the government, they will be awarded any kind of post. So except NHRC, right, Chief Justice of which is given to the ex-CGI Chief Justice of India, there is no other constitutional post or there is no other practice, legal practice that they can indulge in. So this again ensures judicial independence. The jurisdiction of Supreme Court cannot be curtailed, although it can be this is a negative connotation, it cannot be curtailed, but it can be enlarged, right? So Parliament can enlarge the jurisdiction of the Supreme Court, but they cannot curtail it, right? So power to punish it for its contempt, we already have discussed that under Article 129 you have something called court of record, right? And under this court of record you have two things. Among those two things, this power has been given to the Supreme Court that they can punish any individual or any media organization or any organization, right, for their contempt of court. So in contempt of court we had discussed in length. Again I am saying that there are two kind of contempt, one is civil and another is criminal, right? So I am not again going into the detail, I am just linking this topic with the judicial independence, because there we have spent around this court of contempt or power of contempt, civil contempt and criminal contempt, how it is an evasion on this power, is an evasion on freedom of speech of individual and freedom of speech on organization. So that debate as well we had done in that lecture, and that's why I am not getting into the details here. So these are 7 or 8 mechanisms that our constitution does have. Rather, this mode of appointment was not a constitutional mechanism, that was a judicially evolved mechanism. So these are set of rules, or these are set of constitutional principles that ensure judiciary its independence, right? And that's why I was calling that there are set of principles, or there are set of tools evolved by the judiciary, and there are set of tools that has been given by constitution directly that ensures judicial independence. So I hope you will have clarity on all these points. All these points we already had discussed, that it just has to be put on one slide so that you could understand that okay, what are the provision that ensures judicial independence. So I hope you will have clarity over what are the mechanisms that ensure judicial independence. Now we are moving to the next slide. So these are nothing, these are just whatever we have explained, right? This is just explanation of all these points, right? So mode of appointment, in matter of appointment, advice of Chief Justice of India, led collegium is binding on the executive. So all these points are nothing, all these points are just textual explanation of whatever we had discussed in this slide. So I hope these points would be clear to you. Now we are moving to the next slide to discuss this seat of Supreme Court that has been named in Article 130 specifically. So right now we have seat of Supreme Court in New Delhi, right, and that is mentioned in the constitution. So we do have only one seat of the Supreme Court, although in European nation, if you would have noticed, or if you know, right, in European nations they do have different benches of the Supreme Court. One is maybe called to handle this constitutional cases, and another is for legal and judicial cases, right? So we do have only one seat of Supreme Court that is located in Delhi only, that has been mentioned, as I told you that has been mentioned in the constitution. But same constitution also inspired Chief Justice of India with the previous consent of President to establish any other seat of the Supreme Court at other places as well, right? So there has been demand from at various times to establish the Supreme Court in seat of the Supreme Court in South India as well, in North India as well, and rightly so as well, because it is not possible for a litigant from Southern India, if a litigant is not happy with the decision of the High Court of Madras, he cannot walk all the way, he cannot travel all the way to Delhi to have his grievances, to have his litigation resolved in the Supreme Court of India that is based in Delhi. Again, similarly, You cannot expect that somebody from the northeast, if he is not happy from decision of the High Court of Guwahati, you cannot expect that he'll walk all the way, he'll travel all the way. Or few people, few industrialists maybe having all those kind of resources, all those access to the senior advocate, they may have those battery of lawyer, they may have those level of finances, but a person like you and me cannot be expected that we can walk or travel for every hearing or for every date that Supreme Court may give, right? To travel in this New Delhi. And that's why there has been demand from the people, from the NGO, from various interest group, that there may be 2 or 3 another these regional benches, right, not Supreme Court benches, rather regional benches to be established either in one part of South India you can locate. So you can take suppose Hyderabad, right? So this Hyderabad will be closer to Maharashtra as well, it will be closer to the Chennai as well, it may be closer to Bengaluru as well, right? So you can establish one Supreme Court seat or regional bench here. Then in the northeast you can establish suppose in Guwahati near Assam, so it will be accessible to other part, those 7 sister states as well, right? So at least these 2 benches, see in Delhi if it is, right, so people from Bihar, people from UP, right, they can go, people from MP, people from Rajasthan, people from Gujarat, people from Himachal and Punjab, right? So one regional bench here, one regional bench here, and one regional bench for our eastern brothers and sisters, right? So that those 2 regional benches if we could establish, then the purpose of accessibility, at least, right, purpose of justice could be solved for these people, for the southern state and for the northeastern state as well. And it's not that there has not been recommendation. If you see during this first tenure of UPA, there has been recommendation in 2004, 2005 and 2006 from various parliamentary standing committee that these regional benches by the Supreme Court should be set up, and these recommendation had been given in the parliament in Lok Sabha, but it was not widely discussed, right? Law Commission as well has recommended that this demand of seat of Supreme Court is very appropriate and it should be established in the southern and eastern portions of India, right? If you see in Europe, as I was saying, that Supreme Court does have separate courts to deal with constitution. So right now our Supreme Court is very much loaded, right? So all kind of cases, Supreme Court, be it judicial cases, be it legal cases, be it constitutional cases, all kind of cases are seen by the same Supreme Court. But in other country, most developed European country, if you see, they do have separate constitutional courts, right, to deal with constitutional nature of cases, right? Right now our position is that in Supreme Court does not matter what kind of cases it reach, right? Does even if it is dealing with the constitution, the same Supreme Court will establish a bench to deal with those constitutional case as well. But that is not the best practice that is happening in other parts of world, right? They do have, as I told, separate constitutional court and separate legal court to deal with different kind of cases. So why this point? These points has not been discussed in the Lakshmikant. I am discussing just to emphasize that if in future, if there is any movement or any protest or any demand, and if 2-3 editorials are continuously for 2-3 days, if you see in Indian Express or the Hindu, if it is written in a particular year, you can very much expect that in that particular area, if from Supreme Court, if question is asked in the mains, right, there is probability that the question can be framed from this area as well, right? So in the second lecture, whatever we discussed about the qualification, about the mode of appointment, how the judges will be removed, so those are, as I already have explained, that उसमें से prelim से question frame किया जाएगा. But it is topics like this, right, whenever editorials are written on these kind of topics, I'll discuss in there is one particular slide that is dedicated to this area itself, that मेंस में अगर क्वेश्चन फ्रेम करना पड़ा, अगर मैं एग्जामिनर हूँ, राइट, और सुप्रीम कोर्ट से मुझे फ्रेम करना है, सो व्हाट एरिया आई विल पिक अप क्वेश्चंस फ्रॉम. सो वी आर नॉट हैविंग दिस डिस्कशन हियर, वी विल डिस्कस, वी डू हैव, एज आई टोल्ड, दैट वी डू हैव डेडिकेटेड वन स्लाइड टू डिस्कस दैट किस एरिया से मेंस का क्वेश्चन फ्रेम हो सकता है. नाउ वी आर डिस्कसिंग दिस क्लास ऑफ एडवोकेट. सो देयर आर 3 क्लास ऑफ एडवोकेट that do exist in Supreme Court. So you do have senior advocates, you do have this advocate on record, and you do have this provision of other other advocate. So let us discuss these one by one. So before even discussing this senior advocate, let us discuss what you call this advocate on record, and thereafter we'll discuss senior advocate. So what is this advocate on record? So let me show you one picture, and thereafter we'll have a discussion on Supreme Court, right? So if you would have seen, if you know this figure, right, he is actor from Jolly LLB, right? If you have seen, you had this Arshad Warsi. We'll see his picture in the next slide when we'll discuss senior advocate, right? So here you have this Arshad Warsi in front of this judge, right? And he had filed one PIL which does have many mistakes in that PIL. So he asked, this judge asked, which college you have done your LLB from, man? Because this affidavit that you have filed, this petition PIL he had filed against that Rahul Diwan character, right? If you remember this Jolly LLB, right? So this is a well crafted movie, but again I am not imploring you कि आप जाके फिर मूवी ही देखने लगो अपना सारा प्रीलिम का सिलेबस छोड़ के और मेंस का सिलेबस छोड़ के, राइट? आप प्रीलिम ये मूवी मत देखने लग जाना, बट जस्ट एक सीन क्रिएट करने की कोशिश कर रहा हूँ, राइट? सो दिस पर्सन जो दैट Arshad Warsi, he is advocate in this case and he is standing in front of, and he, while filing this PIL against that industrialist son, right, he had done many mistakes. So here he is asking in an insulting way that कहाँ से आपने पढ़ा, कहाँ से LLB किया है वकील साहब आपने? So he responds, sir, merit से, right? So this affidavit is full of mistake. Every line has 5 spell, and that is the word, exact word that he used, and says that advocate को आपने apple लिखा है, prosecutor को आपने prostitution लिख रखा है, right? And he simply tries to throw that PIL, right? See, these kind of mistakes, to some extent you can agree that these kind of mistakes to some extent can be permissible in subordinate courts, in district court, in session court, in front of these kind of judges. But if these kind of mistakes, especially in the circumstances, the kind of education system we do have and the kind of colleges we do have at the lower level or tier 2 and tier 3 city, but these kind of mistake is not acceptable in the apex court like Supreme Court, right? Because ultimately if these kind of mistakes, these spelling mistake or any kind of procedural error if advocate make, right, it is ultimately the client, right, not the advocate, not the judge, right? So if judge's important time is being killed, if advocates important time is killed, right, it is not that they are suffering. The ultimate sufferers are the client, ultimate sufferers are those litigants, right, who are walking all the way from Tamil Nadu, who are walking all the way from the northeast, right, or even from Bihar or even from UP, or does not matter, even if he is walking from Delhi, ultimate sufferer is this litigant, right? If there has been any procedural error, right, that this advocate while filing any case, if he has done, right, there would be a ramification, and those ramifications will be borne by none other than this litigant. And that's why, to maintain the quality, to maintain the set parameters of the Supreme Court, you have something called this advocate of रिकॉर्ड, राइट? तो सभी एडवोकेट जो हैं दिस एडवोकेट ऑफ रिकॉर्ड नहीं बन सकते, बिकॉज देयर इज सेट पैरामीटर्स, देयर इज वन वेल एस्टेब्लिश्ड एग्जाम दैट इज कंडक्टेड बाय द सुप्रीम कोर्ट बार बेंच, right? And in those bar bench, until and unless any advocate has cleared this exam, right, he will not be called advocate on record. And only those people who goes on to become this advocate on record, right, only those people can file any kind of PIL or can file any kind of C. So generally, if you would have noticed, you have these renowned advocates called Kapil Sibal, right? Renowned advocates like Ravi Shankar Prasad, although right now he is a law minister, right? But Ravi Shankar Prasad, then Abhishek Manu Singhvi, right? So these are famous people who Ram Jethmalani, right? So these are the famous people, these are senior advocates rather. So these are not advocate on record. When we'll discuss senior advocates, right, you will see the difference between advocate on record and senior advocate. So although these people are advocate, but most of the time their job is limited only to the clerical staff. So whenever you have to file any kind of litigation, you are not satisfied with any of the decision of the High Court and your case is eligible to go to move in the Supreme Court. So it is not that your case will be filed in the Supreme Court by these people, these Kapil Sibals. They'll argue for you. If you approach them in lieu of whatever fee they have, right, they'll argue for you, but it is not that these people directly file the PIL or file any kind of appellate, right, appellate application, right. They'll not file into the Supreme Court. It is filed ultimately by these people called advocate on record, because it is these people that are allowed to file these kind of things, right? So SC being Supreme Court, being highest court of India, has its prescribed format for filing cases, language policy they do have, and expected level of quality. Hence those eligible to file cases in Supreme Court must have certain qualification, and those qualification are with these people, that is called advocate on record. So there are certain qualification that is sought by these advocate on record if you have to sit in examination. So like we do have in UPSC, so until and unless you have gone beyond certain age, until and unless you have certain level of qualification, you cannot sit in pre. So for them as well to be able to aspirant who want to be advocate on record, right, if they want to write that exam that is being conducted by Supreme Court, so to be able to appear in this exam, there are certain qualification that that aspirant must have. And what is that qualification? So qualification is that they should have the 4 year of experience as lawyer, and thereafter 1 year of practice with any advocate on record, right? So a person who is already advocate on record, right, so that person, with that person, he should have taken training of 1 year, and that the person with which he is taking training, that same person should have experience of 10 years as advocate on record in Supreme Court, right? So that is the level of sophistication, and that is the level of clarity that is needed if one person wants to even appear. That is the level of experience that a person should have if he or she wants to sit for this exam, right? Thereafter, once you have cleared this exam, then you will get this advocate and record, and thereafter you can start filing. Thereafter you can start writing these affidavits or any kind of PIL if has to be filed, or any kind of application has to be filed, right? Then only this advocate on record can file. It is the advocate on record who files the cases on the behalf of petitioner, and not the senior advocate that we will discuss. Court responds, so whatever communication that we do. So suppose if you have appointed this Kapil Sibal, right, as your lawyer in any of the case, now the court will not communicate with you, are the petitioner, right? So court will neither communicate with the Kapil Sibal, they'll neither nor communicate with this what you call petitioner. Does not matter whether you are petitioner or respondent, right? The Supreme Court will not directly communicate either with your advocate directly or you, right? The link will be this advocate on record, right? So you are the petitioner, here is this Supreme Court. Supreme Court will neither communicate with you, neither your advocate, right? They'll communicate through this advocate on record, and finally this advocate on record will notify the details of the cases to you, and he only will notify the details of the case. So whatever briefing that has to happen, right, that senior advocate is often briefed by these advocate on record only, right? So I hope what is this advocate on record you would have understood. Now we are moving to the previous slide to discuss what is this senior advocate. So clear from the name that they are very senior people, right? So the seniority can be attained not only by age but by experience as well. So what amount of experience one person has, right? On the basis of that seniority, Supreme Court does recognize a person as senior advocates for the Supreme Court and High Court. So not only Supreme Court but High Court as well can award this designation of senior advocate to any person based on experience. But it is not only the experience that one person may have that is taken in account while awarding this senior advocate post, right? There are many other things that comes into the play. So along with seniority along with the standing in the bar council, how many pro bono cases, what is the meaning of pro bono cases? So how many philanthropic cases that you have fought, right, for the poor people, right? How many legal publication in various legal journals that you have published, then what level, what quality that your legal argument did have in the previous cases, in the previous 10, 15 or 20 years, right? Whatever your standing had been in bar council. So what is the level of legal argument that you have been presenting so far? What is the expertise? So whether you have expertise in cyber security, whether you have expertise in civil area, whether you have in criminal jurisprudence, right? So what expertise do you hold? So on the basis of all these things, right, there are 100 marks, right, and there are 20 20 20, and based on all these marks that is attached to everything, right, and on the basis of how much expertise, how much legal argument, how many publication, how many pro bono cases, right, and what has been your standing. So on the basis of that, whosoever person secures maximum of marks out of this 100, right, so that is the area, or that is the way these people, advocates, are benchmarked before they are awarded this senior advocate. Once you have been awarded this senior advocate post, thereafter you need not to file this wakalatnama, right? This is a Urdu word, right? So senior advocates generally do not file any kind of wakalatnama in Supreme Court, but they can argue the cases for एनी क्लाइंट, राइट. तो जनरली क्या होता है, आप एक एडवोकेट के, जब भी आपको केस कहीं हाई कोर्ट या सुप्रीम कोर्ट में फाइल करना होता है, यू गो टू द एडवोकेट, राइट. जो भी एफिडेविट बनता है, राइट, उसमें इस बंदे का नाम होता है, इस एडवोकेट का नाम होता है, राइट. और कोर्ट को रिप्रेजेंटेशन जाता है कि भाई ये केस है और इस केस में ये एडवोकेट होगा, right. But about this senior advocate, the speciality is it does not matter whether on this particular paper his name appears or not, right. So on a later stage, suppose officially इस court में इस advocate का नाम है, but on a later stage, suppose a year down the line, if you feel after 5 or 6 sittings, right, if you feel कि भाई this particular advocate is not qualified enough to deal with the case that I am fighting and I am continuously losing the argument, so you may like to go with any senior advocate. So in that case, senior advocate on any particular day, even during the case, he can pop up out of the blue, right, and he will mean simply to the your advocate only, the verbal communication, if your advocate gives that yes, he can represent this particular client, right, in this particular case, that will do, right. No written confirmation is needed. So the senior advocate, that advantage has been given, right, that he can argue for any client without this formal application, right. So I hope that point you would have understood. They cannot appear in Supreme Court without advocate on record and junior lawyer. So in the same movie, the image, if I take from the same movie, just a moment, where is the image? Okay, so same movie, if you would have seen, he is Rajpal Yadav, right? The name of the character is Rajpal Yadav. So he would appear alone, all alone, while he'll always appear with this battery of lawyer, right? He'll be assisted. So these are nothing but junior lawyers. So this is as well a provision that the senior advocates cannot remain present in either in Supreme Court or High Court, or even if they are going into the session court, they cannot go there without presence of this junior lawyer or junior counsel, right? So that is one provision. What is this provision of having advocate on record? So the role of the advocate on record, I already told you that it is the advocate on record that files cases in Supreme Court, not these senior lawyers, right? And that is the reason that why it has been called that they cannot appear in Supreme Court without advocate and on record and junior lawyer, right? Kind of drafting work or clerical work cannot be assigned by any court to these senior advocate, although they can be assigned by normal advocate, but they cannot be assigned. Such kind of clerical or administrative work by the Supreme Court or High Court cannot be given to these senior lawyers. They can argue for their client without having been formally named, right? So this point we already have discussed. So I hope senior advocate and advocate of record you would have understood. Now we are going to discuss other class of advocate that can argue for their client in Supreme Court. So there are something called other lawyer. So if there is any other lawyer like who is not registered in the Supreme Court Bar Council, but if he is registered, he or she is registered in the State Bar Council as well, right? So that lawyer as well can represent his client in the Supreme Court, provided that he is recognized or the case for which he is going to argue has already been filed by the AOR in Supreme Court. So the other lawyers who are registered in the State Bar Council, they can also argue in the Supreme Court. I hope these classes of lawyer would be clear. Now we are moving to the next slide to discuss the language in the Supreme Court. So the language of proceeding, the language of when I am saying proceeding, what is this language of proceeding? So the language of proceeding, the meaning of proceeding is that the communication that will happen between lawyer and that will happen between the judges, right? The communication that is supposed to be with witness. So all these kind of proceeding, all these kind of orders, decree that will be signed in Supreme Court only in the English language, and that is the constitutional provision. Although a constitution has empowered parliament to change this language, that okay, any of the regional language or any of the language that is mentioned in the 8th schedule, राइट ऑफ द इंडियन कॉन्स्टिट्यूशन, इफ़ पार्लियामेंट वांट्स कि भाई उस लैंग्वेज में ये प्रोसीडिंग या ऑर्डर, या फिर प्रोसीडिंग चलो इंग्लिश में हो रही है बट ऑर्डर अलॉन्ग विद इंग्लिश शुड आल्सो बी पब्लिश्ड इन हिंदी एज वेल और इन तेलुगु एज वेल और इन तमिल एज वेल, राइट? सो parliament is empowered, but as of now there has been no change from the parliament side in the language of the proceeding or decree or the orders, right, of the parliament, and right now of the Supreme Court. And right now the position is that Supreme Court, whatever proceeding or whatever order that Supreme Court does publish, right, that will remain in English. There has been again various debates कि भाई इसको जो regional language है, because it is not possible. Suppose we are educated, we UPSC aspirants are educated, but you cannot expect a lame person, a illiterate person कि वो case के में present हो, right? So the happen in Nirbhaya case, suppose. So you cannot expect that Nirbhaya's mother or father to understand the proceeding of the court. Even while they are present in the court, they cannot understand the communication that is ongoing between the lawyer and judges. Later only by the briefing of the lawyer who is representing her, right, or representing Nirbhaya, right, only after the briefing by this particular lawyer he can understand, he or she, that client can understand. Now you already know, right? So in this case the transparency would have been maintained, but you can expect that in normal case, if lawyer is in mood of fetching some money or in mood of corruption, right, so he may brief his or her client in a wrong manner, right? Whatever communication that has gone between judge and lawyer, that client may not understand. On a later stage when briefing is done by the lawyer and client, right, another level of or another kind of briefing may be done, right, just in order to continue the case or just in order to lengthen the case, right? So that is the reason that there has been argument that whatever order or whatever decree or whatever proceeding that happen, right, this should happen in Supreme Court in other language as well. But आप कितने लैंग्वेज में, अगर आप आज हिंदी डालते हो, tomorrow there will be debate for the inclusion of Tamil as well, tomorrow, then day after tomorrow for the Malayalam, day after tomorrow for the Telugu. So there are multiple languages, right? Once the list of 22 languages that is mentioned in the 8th schedule, once their demands has been accommodated, thereafter there will be demand from tribal people as well. Considering the huge amount of diversity that we do have, right, there will be, means this will be kind of a Pandora box that you will be opening. You introduce one language, you recognize one language for any of these things कि इस particular language में हम ये काम करने जा रहे हैं, and the Pandora box will be open, right? कि आप इसको भी include करो, आप इसको भी include करो. So looking at all these factors, this English language, right, that has been allowed, and it is lingua franca as well, right? Connected language, right? So it is lingua franca as well, that this is the language that is understood well by UP people as well and from Tamil Nadu people as well. Although again to people who does not have that amount of literacy, you cannot expect English, but at least to some level, right, on this particular language English पे सभी मतलब सभी states के लोग agree करते हैं कि चलो ठीक है English है, कोई दिक्कत नहीं है. Now again from this area as well, अगर किसी टाइम प्रोटेस्ट या किसी टाइम कंसिस्टेंटली 3 या 4 दिन के लिए आर्टिकल लिखा जाता है इन एडिटोरियल इन ओपेड, राइट, तो यू कैन एक्सपेक्ट कि फ्रॉम दिस एरिया एज वेल अगर सुप्रीम कोर्ट से क्वेश्चन फ्रेम हुआ मेंस के लिए, सो फ्रॉम दिस एरिया एज वेल द क्वेश्चन कैन बी आस्क, राइट. रैंडम फैक्ट्स अगेन जो कि फ्लो के साथ नहीं हो पाए, सो रैंडम फैक्ट्स लार्जेस्ट कॉन्स्टिट्यूशनल बेंच अभी तक जो है वो केशवानंद भारती में हुआ था, एंड दैट वाज अ 13 जज बेंच, राइट, दैट वाज अ लैंडमार्क जजमेंट जिसमें सबसे फेमस दिस बेसिक स्ट्रक्चर डॉक्ट्रिन जो है वो आया था. तो अभी तक लार्जेस्ट जो कॉन्स्टिट्यूशनल बेंच बैठी है दैट वाज ऑफ 13 जजेस. जब भी कॉन्स्टिट्यूशनल बेंच बैठेगी दैट विल बी एस्टैब्लिश्ड ओनली बाय द Chief Justice of India, right? Other judges cannot. About speaking about master of roster, who is master of roster? What is this master of roster? So master of roster is nothing. Roster होता है, right? अगर आप corporate में आपने कभी काम किया है, so there is something, or even normal organization. So roster is nothing. Roster is just allocation of business. कि ये बिजनेस पर्टिकुलरली किसके पास जाएगा, ये काम कौन करेगा और कितने दिनों तक करेगा, राइट. सो दैट इज कॉल्ड मास्टर. ऑन हु विल डिसाइड दिस रोस्टर. So whosoever person has been given the authority of deciding this roster, he will be called master of roster, right. So in Supreme Court, this master of roster is no one but Chief Justice of India. ये मैं क्यों बता रहा हूँ? Because just in the time of Deepak Mishra, there was wide debate, right. So if you remember, in judicial history of India, it had happened for the first time कि 4 सुप्रीम कोर्ट जजेस, जिसमें आपके एक CJI रंजन गोगोई भी उसमें पार्ट थे, जस्टिस चमलेश्वर लोकुर, राइट, मदन लोकुर. सो दोज पीपल वर पार्ट, और उन्होंने ओपनली आके इस इशू पे कि हु विल बी मास्टर ऑफ रोस्टर, बिकॉज एट दैट time there was allegation against Deepak Mishra, although direct allegation means name calling was not done, but there was allegation, indirect references कि important cases जो हैं, right, those important cases are being given to the junior judges, and lesser important cases are being given to these senior Supreme Court judges. So it was a debate it generated whether CGI does have power कि वो master of roster हो, business का allocation करे, या फिर ये right जो है collegium को दिया जाना चाहिए. So ultimately through a decision it was decided कि no, it will be the Chief Justice of India who will be allocating the cases, and that cannot be done by the collegium, but that will be done by Chief Justice of India. So Chief Justice of India right now, the position although it can change because ultimately ये constitution से नहीं, ये judiciary से खुद होना है. So if there is any further PIL in Supreme Court on this question, और अगर Chief Justice is amenable, if he is very democratic, then he can say कि नहीं ठीक है, Chief Justice of India, he is a lone person, and to this lone person this much power should not be given, right. So let this power be transferred to the collegium, right. So अभी के लिए जो constitution judicial position है कि collegium will decide, not collegium but Chief Justice of India will decide allocation of cases कि कौन सा केस. So suppose गवर्नमेंट के अगेंस्ट केस आया, या किसी इंडस्ट्री के अगेंस्ट केस आया, या फिर कोई भी नेचर का केस है, राइट, कौन सी बेंच, राइट, उस बेंच में कौन से पर्सन होंगे, कितने पर्सन का वो बेंच होगा टू डिसाइड दैट पर्टिकुलर केस. ऑल दीज थिंग्स आर डिसाइडेड बाय चीफ जस्टिस ऑफ इंडिया. वेन एवर कॉन्स्टिट्यूशनल बेंच इज सेटअप, द मिनिमम साइज ऑफ कॉन्स्टिट्यूशनल बेंच विल बी ऑफ 5 जजेस. और जब भी कॉन्स्टिट्यूशनल बेंच बैठती है, डिसीजन विल नॉट बी टेकन बाय द कंसेंसस, बट द डिसीजन विल बी टेकन बाय what you call majority. Decision has to be taken by majority, and that's why you would have seen that जब भी constitution bench बैठती है, the number of judges on that particular bench will be in odd numbers, right. Either 3 judge का bench होगा, या 5 judge का bench होगा, या 7 judge का bench होगा. So that is the thing. Just a moment. So that is the thing, either it will be 3 judge bench or 5 judge bench or 7 judge bench, because decision has to be taken by majority. So it should be something like this, right. In the worst case 4:3 or 5:2, right. Worst case would be 4:3, right. So just to ensure कि majority से judgment आ पाए, right, it is established कि भाई odd number के benches आप establish करो, राइट. और जो जजेस एग्री नहीं करते, दे डू हैव राइट कि वो डिसेंटिंग जजमेंट लिख सके, राइट. सो इन केस ऑफ सबरीमाला, इफ यू रिमेंबर इन सबरीमाला केस, Indu Malhotra, right, she had, means that case was decided, if I could remember exactly, by 5 judge bench, right, and the decision was taken by 4:1, and one dissenting judge was Indu Malhotra, and she had written कि नहीं, जो उनकी practices हैं उनको allow किया जाना. So these were some random facts that could not be inserted in those previous 3 lectures with the flow, so that we have mentioned here. Now if the question has to be framed for the mains from this chapter from the Supreme Court, what are the areas from which mains question can be framed? So if I am asked कि भाई mains का question frame करो, so सबसे पहला जो, अगर कोई और raising debate नहीं है, अगर कोई raising कोई उस particular year में कुछ ऐसा judgment नहीं आया, like you had this privacy judgment on Aadhaar in 2018, right, then Sabrimala case, right, then Tirupati case. So if there has not been any landmark judgment in the previous, and if I have to frame question from the static portion, right, besides this, if there is any debate that has generated by any Supreme Court judgment, either from such kind of cases or by on 370 abrogation, right, or decision on the Ram temple, right? So if there has not been any landmark case in a particular, and if question has to be framed from the static area, so the first question can be from mode of appointment. So if you remember, again I am saying it, that in 2014, in 2015, you had this executive which was trying to carve out its role through this body called NJAC, and which was to some extent right as well, because in the debate, if you remember in the first lecture on the debate of NJAC, I had argued why this NJAC was a right body if some modification would have been accepted by the executive, the modification that had been suggested by the judiciary. So had executive accepted those modification in this NJAC was not only beneficial for judiciary only, this executive only, right? It was much needed body for this judiciary as well, because this collegium system is nothing. This collegium system has generated this debate on exclusivity. This body called collegium, right, it has gone on to become this monolithic body जहाँ की judges ही judges को appoint कर रहे हैं. This is leading to erosion of credibility of collegium system, right? So this NJAC body और कोलिजियम सिस्टम में किस हद तक एग्जीक्यूटिव का रोल होना चाहिए, किस लिमिट के बाद एग्जीक्यूटिव का रोल जो है वो खत्म हो जाना चाहिए, राइट? सो ऑन दिस पर्टिकुलर थिंग, राइट, देयर कैन बी गुड एनालिसिस, एंड फ्रॉम हियर अ फर्स्ट क्वेश्चन और अ क्वेश्चन कैन बी फ्रेम्ड. देन जजमेंट ऑफ द कोर्ट इन पर्टिकुलर एरिया. सो सपोज द एग्जांपल दैट आई वाज टेकिंग, सो अगर उस पर्टिकुलर ईयर में कोई जजमेंट आया इन रिलेशन टू द आधार ऑन द प्राइवेसी इशू, राइट, राम टेम्पल दैट आई वाज डिस्कसिंग. सो अगर जजमेंट आया तो ऑफ कोर्स यू कैन एक्सपेक्ट कि अगर सुप्रीम कोर्ट से कोई भी पोर्शन से अगर कोई क्वेश्चन पूछा जाता है, दैट क्वेश्चन डज हैव हाई प्रोबेबिलिटी दैट विल बी फ्रॉम दैट लैंडमार्क जजमेंट, राइट? देन हाई कोर्ट्स पावर अंडर हाउ कोर्ट्स पावर अंडर आर्टिकल 129, दैट इज कोर्ट ऑफ रिकॉर्ड. कोर्ट ऑफ रिकॉर्ड. सो कोर्ट ऑफ रिकॉर्ड में दो पावर थी, उसमें से एक इंपॉर्टेंट पावर है कंटेम्प्ट ऑफ कोर्ट, राइट? सो अंडर दिस कंटेम्प्ट ऑफ कोर्ट, the Supreme Court does have power, or along with Supreme Court, High Court also does have power that they can punish individual and organization for criticism, excessive criticism, or criticism which is unsubstantiated, right? So they can punish. Now how it impinges on the freedom of speech of individual. So there is a debate that we had discussed. So from this area as well a question can be asked. Then we discussed that case for regional bench, right? What is the reason? So reason of accessibility, right, for the natural justice, if you see, right? So for these two reasons you can argue कि regional benches एक south में होना चाहिए और north east में होना चाहिए. So as I already told you that if in any particular year, if there has been 3-4 editorial or 3-4 op-ed that has been written in the Hindu or in any of the important journal that UPSC looks into, then you can expect कि उस पे भी एक question पूछ सकते हैं. Then language policy पे कि why Supreme Court is insisting on English, particularly this English language. Is it colonial hangover or is it something else, right? So from all these area means question can be asked. So this is the way how you prepare for any particular chapter. पहले आप उसको first concentrate from pre-angle. Once you have gathered all the facts related to that chapter, right, thereafter focus on means as well कि means में कौन कौन से questions इस particular chapters में से बन सकते हैं. And as soon you have any article, right, that is being written in the Hindu or Express, right, you can just grab, you can make notes and consolidate those notes for that particular portion. So I hope you will have better clarity on all these things. So with this we are resting this chapter. Now we do have 4 or 5 MCQ. So first MCQ, second MCQ, third MCQ and fourth MCQ. So for this particular chapter we do have only these 4 MCQ, and with this we are wrapping up the Supreme Court chapter. Next we will delve into part 4 of Lakshmikant. Just a moment. Part 4 of Lakshmikant, and we will deal with state government, right? Although it will be part 6 of constitution, right? So part 5 we already have completed of the constitution, but as far as Lakshmikant is concerned, we will be delving into part 4, right? So we are wrapping up the Supreme Court chapter as well and part 3 of the Lakshmikant as well. So till then we come up with this governor chapter, that will be the first chapter in this part 4. Till then we come up. Till then, bye bye.